The opinions expressed on the Custody Queen Show are for informational purposes only and are not a substitute for personal, professional legal advice. The persons discussed are fictional and not based on actual clients.
Thought it was love, had kids in between. You can count on us, we're the Custody Queens. Yeah, you can count on us, we're the Custody Queens.
Good morning, everybody. Here we are on another Saturday, and thank you so much for joining us. And I hope you're enjoying your day and getting a little bit of family time. But today we have one of my favorite custody queens. We have Brittney Van Veen.
She is back and she has been here before. I'm sure you all have listened to the episode, but if you haven't, go back and listen to our earlier episode with Brittney Van Veen. Brittney is not only our dear friend, she is an excellent litigator. And fun fact about Brittney and I, we went to the same elementary school. But we are glad.
We did, and I have the yearbooks to prove it.
Yeah, and my gap tooth princess dress is highlighted there.
I just want to see those.
Yeah, it's brutal. But back to Brittney. We are glad that she is back. And this episode, we are going to get to know Brittney a little more. We're also going to dive into some listener emails. So buckle up, everyone. It's going to be a great show.
Okay, wait. Before we go into it, I just want to say how amazing Brittney looks. And I mean, this whole hot mom litigator thing is just, it's going for you. So if you are not watching, make sure you jump over to YouTube and you watch this episode as well. This episode and all of the episodes are up on YouTube, so you can just see how amazing Brittney looks. You know, I think the first time you were on our show was probably maybe 50, 60 episodes ago. So
it's been a while, a couple years.
I'm telling you, this whole hot mom wife litigator thing, it's really working for you.
I'm wearing pink because it's indicative of me getting my pink back, I think is what they say post having your first baby when life starts to get normal.
So kind of like getting your sparkle, getting your pink back.
Exactly.
All right, Brittney. So I'm going to do one quick CQ talk box with you, just a little icebreaker. So what is one fact about you that most people don't know about?
Most people don't know. Well, I'm an ordained minister, so I am both a divorce attorney and a marriage originator. I like to say I really handle all aspects of the marriage market. I can get you in one and I can get you out of one. So yeah, I've done a couple weddings before. I got ordained when I was in law school. I've done elopements. I've done like full scale Temecula winery weddings. So I'm really, once we finalize your divorce, if you ever decide you're ready to do it again, give me a call. I can help you. I'll give you some legal advice before maybe on what you should do to prepare.
If they hire you to do the prenup before you are the marriage originator, is that a conflict of interest?
That might be a conflict somewhere. But I can get you in touch with some people who can give you some maybe prenuptial advice, and then help you sign on the dotted line to get that marriage official.
That is awesome, and I think you have the absolute perfect personality to officiate a wedding and a marriage, because I think that you would be so empathetic on one hand, but so real life, and just, your one-liners, I'm here for it.
And she's an excellent litigator, which makes her a good public speaker.
Oh yeah, since day one. Can't get me to stop.
All right, ladies. I want to dive into the first listener email, because I always like getting everybody's opinion when we do these, because oftentimes we will all come to the same conclusion, but our math is not always the same. So, okay, the first one, Britt and Sam, this is one of the first emails that we got to our DM box, and I want to make sure we get to it. Hi, Queens. My ex-husband has our child every other weekend, and my son has a severe peanut allergy. The doctor confirmed the allergy, but he keeps giving him peanut butter and foods made his peanut... Sorry. But he keeps giving him peanut butter and foods made in the peanut facilities, and my son keeps breaking out with rashes and hives. Is there anything I can do?
Oh, man. Obviously, some concerns there. Whenever we're dealing with a custody scenario, the court is always looking at who's going to be acting in the best interest of the children. And one of the ways that they look at that is looking at health, safety, welfare. So obviously we're looking at some health concerns. We're looking at some safety concerns. When I look at this as an attorney, I start, playing it through in my head, and I start asking some questions. And the questions I'm wanting to know is, how do we know this? Is this reliable information that we're getting? Obviously, you can see the hives, you're seeing the physical reaction. Is this just coming from word of mouth? Have you attempted to mediate it with your co-parent? Have you discussed the concerns with your co-parent? If you've tried to mediate the concerns, if everybody, is aware of the allergy and you've tried to mediate it and it's still not resolved, I think that's when we're coming to a point where we're looking at getting court intervention, getting the judge to intervene, and whether that's looking for protective orders that are going to make sure that everybody is complying with doctor recommendations and acting in that health and safety of the child. If it continues, if you've already been to court and this is an ongoing issue, that's when we start looking at further protective measures. If this is an ongoing problem, that's where we also start having some red flags about child neglect, child endangerment, essentially, because if you're knowingly exposing a child to something that they are allergic to, it's going to be a problem in the long term. So it's definitely something that can kind of escalate in nature. But I think getting family court involvement is going to be something that if the communications amongst the co-parents don't resolve it, you're looking at going to the family court on maybe even on some sort of emergency basis to get some protective orders in place.
Yeah, I think getting an order, obviously, if you can't resolve this, that would be the most efficient way and the most effective way. But a lot of times, parents going through this transition don't always see eye to eye. If it's not an isolated incident and you have to get a court order, you at least have the threshold, you have the order, and now there can be a violation of the order, and then the court can take steps from there. And it can be something as, hey, if one parent is not recognizing that this could be a very serious or is a very serious medical concern, then we're going to go to supervised visits if that's the point that we have to get to. Hopefully it doesn't get there.
All right, next question, just to keep us on track here because we love to gab, is, hi Sam, hi Kristen, I have a question about our court order. My husband is supposed to take our son every other weekend. He never sticks to the schedule and changes it at the last minute, which inconveniences me. What do you recommend I do? Can I go back to court for him not complying with keeping the kids on his time? Thank you.
This happens a lot. This is not an uncommon scenario. I'll start with saying I remind my parents and my clients oftentimes that we have these custody orders and they're created in a courtroom, in the hallway outside of a courtroom, in the contemplation of being in a litigious environment, in a courtroom environment. So because of that, custody orders exist in a bubble, and real life is going to happen outside of the bubble. So I think that there's always an element of flexibility that's required of co-parenting, because real life is going to happen, and a court order just cannot possibly contemplate every real situation that's going to happen. You're going to get a flat tire, a car's not going to start, someone's going to be sick. Things happen, real life happens. But what it sounds like we're getting in the email is more than just the day-to-day, sometimes things happens and flexibility needs to come into play. This is a pattern. If it's happening frequent enough that you're contemplating going back to court, what do you need to do, moving forward, then it's obviously a pattern. There's a couple different parts of it that we need to look at. I mean, when you're having the kids more than the schedule contemplates, it could raise some child support issues because you're additional mouths to feed for more time than you're expected to have them. So it can raise child support issues. One of the words we use a lot is status quo, is what's the status quo of the actual schedule that's being operated. And if the status quo has changed for whatever reason, whether that's he can't follow the orders, he can't or doesn't want to follow the schedule, then it certainly could be a change of circumstances that the court could look at changing that schedule and, again, potentially changing child support. It's just a balancing as well of, if you're ready to make that order, or sometimes, there's some circumstances where parents, it's nice to have the extra time and it's not worth it to rock the boat. So maybe the advice I might give you is consider, do you want to end up back in that litigious environment where he sees you file and then maybe decides I'm going to start practicing my weekends again? It's definitely a balancing and something that we would discuss and kind of contemplate deciding what the next steps are.
Well, my brain goes completely the other way, and I think Brittany might be a little bit more empathetic than I am. So I look at as a lot of people want to have the visitation and the custody order on the paper, but they don't necessarily want to have that much time. So it's like they want that joint legal, joint physical, but they really don't have the ability and or the desire to have that much time. So I would just, if I had to answer this in 90 seconds, I'd say, okay, is it an isolated incident? Oftentimes there's a new relationship and they don't want to give up their weekends all the time. Is there a change in a schedule, a school schedule, a sports schedule, a job schedule? But I go straight to document, document, document. All you can do if you're trying to change a court order is show that the court, through talking parents, our family wizard, text message, however you communicate, show that this is a consistent problem. This isn't, hey, once a month I'm working late and I'm flying out to go visit my mom tomorrow. Can we modify this? Is it every Wednesday or Thursday? Hey, by the way, I can't make it. And now we're letting kids down and now we're frustrating the other parent's schedule. And if it's a continuous problem, give it a period of time, 90 days, 5-6 missed visits, then go back and modify it.
All right, next question, ladies. Hi, Queens. I have a child support order in place, but he consistently is late with the payments, which makes it hard for me to pay my bills on time. Is there any way to enforce the payment schedule so that I receive it promptly? Thank you.
Oh, yes. There are many ways to ensure that your child support payments are timely received. Child support is a primary of your debts that are supposed to be paid, meaning that the court expects you to be paying your child support pretty much before anything else. So there are garnishments in place that can be put into place where if you have a W-2 employee, we can have the pay taken out directly from his paycheck. That's usually the easiest and the most reliable way to ensure that you are getting paid every time he gets paid before he gets the choice to pay it or not pay it. It's going to come out directly. That gets served on the employer. There are also a lot of different methods of enforcement that I would spend hours talking about, but we can go. There are assets that can be gone after. There are punishments the court can put in play for failing to pay your child support. It can even rise to the level of potentially being a misdemeanor if you don't pay your child support. So a lot of options. I encourage you to call the Custody Queens and we can talk you through what specific options would make sense for your case. But there are many tools at our disposal.
Thank you,
Sam.
Brittany. And just to add to
Sam.
that.
Well, hold on. I was like, I got a good question for you, Sam. What if, in addition to the baseline support order, that sometimes he pays you on time or she pays you on time and it's great, and then other times, it might be late. But what if, in addition to the normal support order, there's like a bonus or, the court ordered him to pay a percentage or her a percentage? How do I get that money, guys? Come on, Queens, tell me.
Well, I mean, it's kind of a two-part trick question. My boss is hitting at me right now, you guys. But what she's talking about is an Osler-Smith or Smith-Osler, which is a series of cases that talk about dealing with having additional and accounting additional income for the purposes of support. You would be surprised what the court will consider when it comes to income available for support on the front end. Sometimes it's wider than the tax code. So you definitely want to talk to an attorney about that. And just as Brittany had mentioned, how every kind of fact is different, and to call your attorney specifically if you have any questions about how to handle your case. You can do so if you want to call the Custody Queens at 1-800-419-7772. That's 1-800-419-7772. But to then circle back and answer the rest of Kristen's question, once there is a support order in place that called, for example, a Smith-Osler, then you kind of route back to Brittany's sort of analysis. Maybe the income withholding order is not the best tool in that circumstance. However, there are other enforcement mechanisms, and the court is really not typically going to ignore such a primary and foundational payment, especially for the benefit of the children. And although they are often kept separate, support and custody and visitation, it kind of all encompasses the context of your dissolution case. So you certainly don't want to make a bad impression of the court on one issue when you have the rest of the issues to divide or to deal with in front of court.
Yeah, and everyone thinks that maybe the income withholding order, the wage garnishment, however, people use different words for it. But once you get the order, that's just the first part of the prong. The second prong is actually enforcing it. But it is not a so 15 years ago when I was doing this, it was, oh my gosh, I have an enforcement or I have a garnishment and this looks really, really bad. It's very, very, very common. And I think that you actually are setting yourself up for failure, in my opinion, by not having the garnishment or not having the wage assignment, because then feelings get involved. And then it's like, oh, hey, can I just get a couple more days? This is due. And then that person feels like they're getting taken advantage of. When you got a support order, it's directly taken out of the paycheck, usually the half on the first, half on the 15th, and it is what it is. But I think just like every agreement, it should all be memorialized in writing. That eliminates so many problems.
All right,
All right.
Back on that really quick. I was just going to add, I do garnishments sometimes when I have the paying parent. It's not a garnishment or a support order. It's not something that's just, oh, I'm enforcing. When I have a client who's paying, we talk through and I've prepared the income withholding order because it takes the think out of it and it's easier to
and then
make
they
sure
can't
it's
come back
done
and
and
say
it's done
that you didn't
timely.
pay. Yeah, and then they can't come back and say you didn't pay and want attorney's fees and arrears and all that good stuff. So I agree. Sometimes I'll even file the motion to get a support order to make sure that it's crystal clear that my client is willing, able, and capable of making the support payment and get in front of any allegations that somebody's not taking care of their kid. All right, on to the next, queens. I just found out my husband fathered a child outside of our marriage, and that child's mother is now seeking child support from us. I am considering filing for divorce, but I'm worried how this might affect me financially with regards to the unknown child. Please help Kristen, Sam, and Brittany.
I'm going to let Kristen answer this one.
I'm going straight to Brittany. But I do want to say this is a really tough situation, and I think you're handling it with grace if you're not immediately running to file for divorce. I think that you're actually looking at this from all perspectives. And so the fact that you are getting information and knowledge to be able to make an informed decision, I think that is very, very powerful.
And I'll
right,
jump
Britt,
on that.
take it away.
It's obviously a very unfortunate circumstance. This isn't how anybody envisions their next step moving forward. I think the concern that you have, well-founded, and I would be concerned as well. You don't have an obligation to support a child that's not of your relationship, of your marriage. I don't think that there should be a concern in a direct impact to you financially, especially in the context of if you were to move forward with the divorce. There are times where if he's supporting another child, that gets factored into some of our calculations with support. And if you have a child and we're looking at child support moving forward, if you have if you're proceeding with your own divorce case, there it can be a factor in his income and access to financials, but there's no direct obligation for you to support another child. If you stay married and someone goes after him for child support, in most circumstances, your income won't be considered for the purposes of calculating child support for that other child. There are exceptions to that, which again, I could spend hours talking about the nuances of the law and different arguments we can make. But in the context of you remaining married, typically the other spouse who's a non-parent's income isn't considered for support purposes. It would be looking at your spouse's income for purposes of support of that child.
But it will unequivocally affect your household financial situation. And that's what people don't realize when they call us. You don't realize that when you have a support order or anyone of the marriage, yes, your income's not counted, but at the end of the day, you're now making another payment to a third party. And so when people split up, it's like you have a lot of people have one income now paying for two households, or you have two incomes paying for three households. So on some level, yes, it will affect you financially, and other things if you were to walk away and file for divorce. I don't think it would necessarily affect what's in your bank account, but because he would be paying, it would have some effect overall on the whole family. Sam, I know
Yeah,
your
and
wheels are spinning over there.
just to add on that, I think that it's going to depend on the facts of your case and who makes the money in the relationship, right? Because if you are presuming that you're staying married, yes, they're not going to use you. Typically, they're not going to use your income. They'd use your spouse's income, the person who has established parentage with a child outside of the marriage, but that is still going to be potentially using resources that are community monies earned, right? If your spouse's income would otherwise be community monies, that could still, maybe it's not being, your income isn't being used in the calculation, but it is still potentially being used as a resource to pay support. And then on the reverse end, if you are going through a dissolution case and there is court ordered child support, that could be something that the court looks into and takes into consideration potentially in if in these circumstances we are producing a spousal support payment, they would still be considering a otherwise court-ordered child support payment. And I think that I agree totally with Brittany and Kristen, and I think we all probably kind of agree with each other, but this brings up a huge point that although child support is based on guidelines, statewide calculations, there's a lot of potential exceptions, deductions, and sensitive income variables. The input is so important to what the actual order is and how it can have an effect on your case or potentially your spouse's case. And so if you have specific questions regarding your case and you want to chat with Brittany, Kristen, or I, please feel free to give us a call. Again, our number is 1-800-419-7772. That's 1-800-419-7772.
And ladies and gentlemen, like your taxes, don't try this on your own. Hire an expert, okay? Because it can be a gross deviation from what should have happened and what was ordered. But playing my little self here, I want to ask both of you what, and I see a scenario where it could potentially affect wife here. If they stay together, isn't there some way that the court can consider the expenses of the whole household?
I think the court, even bigger picture, one of the things we
if there's
didn't really
a request for attorney's fees attached here too for child support,
there's the potential to look at the expenses, the income and expense declaration that'll have to be completed is gonna look typically at the household expenses. It's also required to list who's living with you, what their income is, how much is being contributed by another individual to those household expenses. There's also discovery that's done in any child support proceeding. There's certain financial discovery that can be done and exchanged, which means when you're married and you maybe are tying yourself to some of your otherwise confidential or private information that's protected, that could become discoverable by the nature of the litigation that's happening with that other child. So if you're filing joint tax returns and your spouse, if you decide to stay together, you file joint returns, those could have to be turned over. If you've got joint bank accounts and discovery's done to look at bank accounts, to look at access to funds for arguments on attorney's fees, there's, I think, an element of your finances that comes into play there, but also, your private information. And that's something we see a lot of, even with new spouses, post-divorce litigation, when there's new relationships, is that it opens the door to potentially having your information shared with someone in a way that you're not necessarily comfortable with.
That's a great point, Brittany.
So you're saying this is not a yes or no answer?
I'm saying it depends, which is a lawyer's favorite response to pretty much everything.
Anyone that's been listening to us for the last 5 years, I know that some of you want a black and white question and a yes or a no, but because we analyze things for a living, we will always show you all of the potential concerns that we have and get those out. So at the end of the day, the advice that all three of us would always give is educate yourself, have a consult, have 2 consults, make sure you understand if you're staying in the marriage, what are your consequences and your benefits? If you are leaving, what are things that you should be aware of, and educate yourself. Knowledge is always the best answer, and call the custody queens.
And if you're wondering what it's like to hang out in our office talking about cases and legal issues all day, this is what it's like.
Yeah, imagine a attorney meeting lunch with 20 brilliant minds. It's very funny that we all have such complete different analysis. Okay, we have just a few minutes, but I have one more, and this one actually comes up quite a bit in all three of our cases. I have a couple that I'm dealing with this right now, and it says, "Hi, Kristen. Hi, Sam. I am going through a divorce, and my ex-husband loves to drink, and I'm always afraid he's going to drink and drive. He has a couple DUIs from 10 to 15 years ago, but I'm just not convinced that he's still not drinking. What can I do to protect my kids?"
So much. This is very common. And I think I've said that like 3 times on different emails. Unfortunately, this is an issue that pops up a lot. There are a lot of options of what the court can do. Again, we spoke earlier about health, safety, welfare of the children and protective measures the court can put in place. And just like with an allergy issue, with a potential alcohol concern issue, the court has a lot of options that can be put into place. There can be specific orders made about alcohol consumption during custodial time and in advance of custodial time. If it rises to the level, there's different testing protocols that can be put into place. I have a number of cases where SoberLink in particular or other breathalyzing services are utilized, which requires testing and monitoring during custodial time or even sometimes outside of custodial time that will essentially give you live reports of someone's potential alcohol use. They can be restrictive measures put in place on someone's ability to transport the children, having either third parties be responsible for transportation, or sometimes we have the parent that's not having a concern with alcohol at that point in time be responsible for more the bulkhead of the driving for visitation exchanges. If it rises to an even higher extent, we have alcohol assessments that can be ordered where there are experts who can assess someone's alcohol use and potential abuse and give recommendations for treatment moving forward. And we can have review hearings where the court's monitoring that treatment. Again, it's very case and fact specific, but we are in that court system where the court has the ultimate goal of doing what's best in the best interest of your children, and their safety is of the most importance. And we have a lot of options available in the courts to address the concern and not just address it, but be proactive and protective moving forward.
So call us, and so we can talk about the specific facts in your case. But the answer is yes, yes, yes. There are safety precautions. Sam and I are huge fans of SoberLink, and nobody writes a better stipulation and order regarding SoberLink than Miss McBride herself. And we have done many and many and many of these over the years, like Brittany talked about. But they are very case sensitive and driven, analysis. And we are all happy to talk to you about all of your options at this point.
So it looks like we are out of time for today, unfortunately, but it was so fun to have Brittany back. I get the pleasure, and Kristen does too, of seeing Brittany all the time. We'll definitely have to have you back again soon on our show. So thank you for joining us, and thank you to our listeners out there on Go Country 105 for listening to another episode of Custody Queens. Please make sure to check out all our socials. You can look online and check out all our past episodes. And again, if you want to get a consult with any of us queens, you can give us a call at 1-800-419-7772. That's 1-800-419-7772.
And you can email these questions to any of us on Instagram, and we will try to get back to you as soon as possible. You don't have to wait until we do these episodes, but keep them coming. And always remember,
let love rule.